Good morning, Munandal. Research methodology, legal research methodology, tools of study in a narrative case storytelling manner of leading international case law. King George III was still upon the throne, and Sir James Mansfield was Lord Chief Justice of the Common Pleas. Sir James was at this time 79 years of age. He had an ungraceful delivery and a lusky voice, but his judgments were sound in law, if unpleasant to the ear. Mr. Sergeant Suffolk, Solicitor General to the Prince of Wales and afterwards Lord Chief Baron of the Court of Exchequer in Scotland, appeared for the defendants. He was a great lawyer, and but for the misfortune of his deafness, would have probably held very high judicial office in England. Truly, it was a battle of giants, and the problem raised was worthy of them. The original action, which was for goods sold and delivered, had been tried before Sir James Mansfield and a special jury at the Guildhall. Cantasecue was a member and a director of a Spanish trading corporation called the Philippine Company. He had come over to England to select a large assortment of goods destined for Lima. At the London, a firm of Larazabal, Menojo, and Trotiga assisted him to providing the goods, and they applied to Addison, with whom they had previous dealings for 20 years. And Addison went by appointment to their house in the city with patterns of goods. There he found Cantasecue, who examined various patterns, cheapened the prices, mentioned the market for which they were intended, and told Addison that he should charge a long price, and he, Cantasecue, would himself receive the bounty on exportation and stipulated for 15 months' credit. He took the goods home to his house in Clarges Street and kept them a week to examine. A clerk from Addison's house frequently attended upon him there to show and explain the patterns. Addison received a written order from Larazabal, Menajo, and Trotiago for a quantity of these goods, after which Cantasecue required of Addison an abatement of 6% on prices of them. This abatement Addison refused to make, and the parties were about to terminate the treaty. But at length, Cantasecue agreed to give the whole price record and told Addison that he might proceed to execute the order. Addison had his clerks had several other meetings with Cantasecue, and several other parcels of goods were ordered by Larazabal, Menojo, and Trotiago, which had been selected by Cantasecue at these meetings, but they referred Addison to Cantasecue for instructions as to the mode in which the goods were to be packed for exportation, and Cantasecue have those instructions. The invoices made out of by Addison to Larazabal, Menojo, Trotiago, and they were debited in Addison's books for the amount of the long price. This is the cause of action. The invoices were made out by Addison to Larazabal, Menojo, and Trotiaga, and they were debited in Addison's books for the amount of the long price. Larazabal, Menojo, and Trotiaga in their books debited Cantasecue with the amount of the invoices and also with a commission of a percent, which were their usual terms of dealing with him, and they credited Addison with the amount of invoices. Upon an occasion subsequent to the sales, Larazabal, Menojo, and Trotiaga having applied to purchase some goods of Addison, the latter said that he thought he had for that time extended his credit for enough to them and declined to furnish the goods. Larosafal, Menoja, and Trotiaga gave the orders for packing and shipping the goods and in their own names, but in pursuance of instructions given by Kantasaku, they chartered a vessel to Lima in which these goods were conveyed and instructed the master not to part with the return cargo until payment of the freight and of their demand on Kantasaku. The master did not deliver the return cargo until after a sum of 72,000 pound had been deposited by Kantasaku for their security. Lara Safal, Menojo, and Trotiago became bankrupt. One of the partners in their house stated that the house purchased these goods of the Addison on their own credit and account as they would any other goods for which they have occasion in their trade. They have insured them in their own names for which they had a further commission of half percentage. Addison then sued for Kantasaku. For the plaintiff, it was contended that though the credit was given to the Lara Safal, Menoja, and Tratiaka, yet that as the defendant had the goods, he was liable to pay for them. That this was only the common case of a broker buying for his principal. That principal, when disclosed, was liable. Sir James Mansfield left it to the jury to say whether or no Lara Safalkama Menoja and Trotiaga did act as a brokers. He observed that as the defendant saw and handled the patterns and was seen in the business, if he had been the purchaser, most probably the credit would immediately have been given to him. The jury being of opinion that the goods were sold to Lara Safal as principal. Once again, I repeat the brief. The jury being of opinion that the goods were sold to Lara Safal as principal found a verdict for the defendant. Mr. Sergeant Best obtained a rule, and now the real rule of battle began in the court of common pleas. Lara Safal, Menoja, and Trotiago were the mere agents set best of the defendant, which was indicated by their receiving a commission. The plaintiff, in fact, had a security of both parties. For under the return order, which did not affect real buyer, the agents were liable. Once again, I tell, under the return order, which did not affect the real buyer, the agents were liable. And the defendant was liable because he had the goods which raised a sufficient contract. For by the law of England, he who has the goods shall be obliged to pay for them. Understand? In this case, obligation arises because of holding the goods. It had been admitted that when a broker contracts for a principal, principal may be unknown. If one partner only contracts, the others, when discovered, are liable. The principal could only be discharged by payment, and that payment must be to the vendor if he is known. The previous ruling is the principal means owner of that contract, primary. The principal would only be discharged by payment, and that payment must be to the vendor if he is known person, if he is a known person. If he is unknown, the purchaser must pay the agent. Understand? There is a principal, there is a buyer, two extremes. In between, agent is there. Now come to the spirit of this case. The principal could only be discharged by payment, and that payment must be to the vendor if he is known person. For the principal and vendor, they both are known person. If principal is unknown or vendor is unknown, the purchaser must pay the agent, in between agent. but unless he pays one or other, he is liable. Stifford contended that the effect of the evidence was the Lara Safal, Menoja, and Trotiega were not the agents of the defendant in the affairs, but were in fact the principals to whom the credit was given. For that, otherwise, the defendant could never have obtained the goods, for no one would have given credit to a person unknown. Underline the word. Justice Sefford contended no one would have given credit to a person unknown. Isn't it? It is the truth. It is the truth. No one would have given credit to a person unknown. Sir James uh, Sir James Mansfield, in delivering the judgment of the court, said, "If a man selling to another for the use of a third who stands by and is known may make the contract with the buyer without making third person responsible, certainly this is that case. The insolvency of Lara Savall, Menojo, and Trotiaga may make an unfortunate difference in the case as to the consequences, but it will not alter the liability. We who are called on to set aside this verdict must, in order that to say on this evidence that Lara Safal, Menojo, and Trotiaga only were not to be the debtors, but that the defendant also, who was to buy these goods for the Philippines company, was to be liable." Once again, I repeat that. Come to the conclusion. As per the words of Sir James Mansfield in delivering the judgment of the court, we who are called we who are called on to set aside this verdict must, in order that to say on this evidence that Lara Safal, Menojo, and Trotiago only were not to be the debtors, but that the defendant also, who was to buy these goods for the Philippine company, was to liable. But we can find no evidence to warrant us in that conclusion. The rule must therefore be discharged. This is the noble leading case law Addison versus Cantasecu, ADDISON versus GANDASSEQUI, regarding principal, debtor, agent liability. In this, it is a precedent case law. So in this case, Addison then sued the Cantasecu. So finally, Sir John Mansfield, in delivering the judgment of the court, come to the conclusion that the insolvency of Lara Safal, Menojo, and Trotiaga may make an unfortunate difference in case as to the consequences, but it will not alter the liability. Those who are attaining insolvency means they are not having liability. That it is not its meaning, isn't it? Likewise, the insolvency of Lara Safal, Menoja, and Trotiaga may make an unfortunate difference in the case as to the consequences, but it will not alter the liability. So they are liable persons. Insolvency persons are liable. We who are called on to set aside this verdict must, in order that to say on this verdict that Lara Safal, Menojo, and Trotiaga only were not to be debtors. They are not debtors, but that the defendant also, who was to buy these goods for the Philippines company, was to be liable. Even though Lara Safal, Menojo, and Trotiaga were not debtors, the defendant also, who was to buy these goods for the Philippine company was too liable. But we can find no evidence to warrant us in that conclusion. The rule must therefore be discharged. So, previous ruling regarding principal agent vendor rule is discharged. The rule must therefore be discharged. The previous rule is discharged in this leading addition and consecutive case law. This is the tools of study based on case analytical study in legal research methodology. We will share legal research methodology papers and tools of studies as per the International Court of Justice. Go ahead, rule your own arena. Thank you.